First up, we're in Bay City, Michigan for a virtual hearing on a bond violation. 6 weeks earlier, deputies responded to a report that 53-year-old Roger Nickel was throwing trash cans at a gas station. When they arrived to question him, Nickel ignored orders and pulled his arm away while being handcuffed. He was arrested and charged with resisting police, malicious destruction of property, and disturbing the peace. He was released on a $5,000 bond, but a month later, he was allegedly caught drinking alcohol, a violation of his bond conditions. Today, he's in court before Judge Timothy Kelly to address the violation. Nickel appears from jail, while his public defender, Aaron Hetherington, is in the courtroom.
Mr. Hetherington, do you know how your client wishes to proceed on that alleged bond violation?
Most attorneys know the answer to this, but Hetherington punts the question to his client.
We would look to Mr. Nickel to see how to proceed for the bond violation. Mr. Nickel, the judge would be inquiring whether or not we would like to have...
Hey, hold up. I understood what he said. You know why you don't know why? Because I've called you 20 times and you haven't answered the phone and you haven't bothered to show up or talk or anything. So how are you an attorney? Okay, let me take it from here. I wish to plead not guilty to all charges, and I wish it for a jury trial. What else you got?
Today we're here, sir, regarding an alleged bond violation.
Not guilty.
Hetherington attempts to explain his failure to communicate, but Nickel doesn't want to hear it.
I was out of town on vacation that was scheduled 6 weeks in advance, and that's why I hadn't had any contact with Mr. Nickel.
Mr. Nickel.
Your Honor, permission to be excused.
Just everybody calm down. You know, it's not pleasant to...
Yeah, it's not a personality contest, it's a job. You were assigned the job and you didn't do it.
Hold on, Mr. Nickel, that's not how... Mr. Hetherington is entitled to his time off.
His time off is fine. This was scheduled. He knew his time off, and he knew it was scheduled, and he didn't do a damn thing about it.
Nickel's temper's been building throughout the hearing, and now he seems about ready to explode.
Wait a second. I've been in the military since 1986. I'm a decorated veteran. I'm a war veteran. I've got more combat time than anybody else around here. I have never had a single charge in 53 years. I've been playing face with you two guys. I'm about at it.
What'd you say? What did you say you're playing with us?
I said, let's get on with it.
Judge Kelly doesn't seem to appreciate Nickel's colorful language, and Nickel now seems to realize that his temper may have gotten him in trouble with the court.
I said, let's get on with it.
No, you're playing face what?
I don't know.
You want me to play that back?
I have never had a single charge in 53 years. I've been playing face with you two guys. I'm about at it. Your Honor, what are we doing?
I'm asking you a question. That's what we're doing.
I don't know.
You said you've been playing face with us?
I don't know.
Is that... Did you say that?
Nickel is not so talkative anymore, and Judge Kelly's heard enough.
I think you're in contempt of this court.
Your Honor.
You don't do that. No. It doesn't matter if you serve a day or 20 years. You do not get to say that in my courtroom or in any court. You are in contempt of this court.
Okay.
And I'm finding that you're done. All right? You're going to receive 93 days right now. You do not ever do that again. 93 days in jail, contempt of this court in our presence. We're going to adjourn this matter out. You're all done for today. We're going to get a new date. Nobody gets to get away with that. Nobody.
Nickel was taken back to jail for the bond violation and contempt of court. A week later, he struck a deal and pled no contest to malicious destruction and a lesser offense of attempted resisting police. The disturbing the peace charge was dropped. He was eventually sentenced to a $325 fine and 93 days in jail, with credit for time served on the contempt charge. Next, we go to Chesapeake, Ohio for a bond violation hearing. 40-year-old Crystal Gansen has been charged with theft. 4 months earlier, Gansen was arrested and released on a personal recognizance bond. As part of her bond agreement, she was ordered to wear an ankle monitor and submit to drug and alcohol testing. Today, after not complying with her bond conditions, Gansen appears before Judge Donald Capper to hear if it'll be revoked.
The reason that she's in custody is she's not compliant with her ankle monitor, Your Honor. I know that she is supposed to report weekly on a Monday to have inspection done, and she has failed to do that since the time she's had it on. She's not reported to any probation department since it's been on her.
Call you back on the docket later, and we can do some discussion with both probation departments and council and figure out where we're going forward. In the back, ma'am. Ma'am, in the back.
Gansen doesn't seem happy with how things are going so far.
In the back, ma'am. Ma'am, in the back. Okay, I hold you in contempt. Come back. Now you're back.
Ma'am.
You're back over here. Bring her back.
Hey, God.
I hold you in contempt for your language. In the back.
Minutes later, Gansen returns with a seemingly better attitude. That's her attorney, Warren Morford.
Judge, I think that she would like to address the court about her behavior.
I'm more concerned about her drug screen and her sobriety. In October, you screened for amphetamine, buprenorphine, cocaine, and methamphetamine.
I'll go to the street here every week. That wouldn't hurt her. Some kind of accountability helps me.
I have a report to whom it may concern. Crystal Gansen does counseling here weekly and does a weekly drug screen.
You said as long as that worked out okay, then it would, I could stay there.
Well, it's not working out okay. It's not working out okay. I had thought about making you spend the weekend in jail over this, but I'm going to give you the chance to go to treatment. You've got little kids.
Yes, sir.
You're having a huge, just listen to me, you don't need to say anything. You're the most important person in their life. And if you're using substances, that has an impact on them. You've got to get clean. Quiet. You've got to get clean. I'm giving you an opportunity to do that, not only for your sake, but mostly for theirs. I'm assuming you love your kids.
Very much.
I want you to come back with a good report, take this opportunity to get clean, and I want to support you. I want to see you do well.
I actually am doing it's hard for you.
You're not doing well. You're not doing well. Quit saying that. You had dirty screens last month. You got a dirty screen today. That's not doing well. Part of this is admitting you got a problem.
I do.
Okay, so let's address the problem. You need inpatient treatment. That's what you're going to get.
The judge dropped the contempt charge and ordered Gansen into a drug treatment center. After a month, she completed the program and was released. But a month after that, Gansen failed to appear at a pretrial hearing, and a warrant was issued for her arrest. Her case is pending. We're in Longview, Washington for an arraignment. 38-year-old Christopher Belvoir has been charged with resisting arrest and disorderly conduct. Several hours earlier, Belvoir was arrested for wandering around a YMCA at 4 o'clock in the morning. Police were called to the scene, and after the defendant failed to cooperate, he was arrested. At the time, Belvoir was free on a personal recognizance bond for assault and other charges. His bust at the Y was a violation of his bond conditions. Today, he appears remotely before Judge Edward Putka. And right off the bat, things get off to a rocky start.
There are 2 charges here, resisting arrest and disorderly conduct.
Hey, can I tell you something?
Just a minute.
I didn't do either one of those thing, sir. So
Okay.
you're discharging your officers is outrageous.
Mr. Belvoir, if you keep talking like that, I'm going to send you in the back, no bail, and we're going to come back to you tomorrow.
All I was doing was trespassing at YMCA.
Mr. Belvoir, one more time, you're using obscenity in this courtroom, and I'm going to put you in the back. You're not going to get out of jail. Just
I
listen.
want my lawyer present right now.
Okay, just listen up.
That's my cloaky. I'm not going to listen to you with a bunch of fake charges.
Okay, just take it easy. Okay, calm down.
Okay, go ahead. Read out the fake charges, sir.
All right, so the charges are resisting arrest and disorderly conduct.
They're both lies.
Okay. The maximum penalty for this is 90 days in jail and fines and cost of $2,050. Do you understand what you're charged with?
Yes, sir.
The judge goes on to explain the defendant's rights before turning to defense attorney Oleg Balaban.
I find probable cause for the charges. Do you want to enter not guilty, please, on his behalf then, Mr. Balaban?
Yes, Your Honor. I said not guilty. Plead not guilty.
Judge Putka asked the state for its bond recommendation.
The city is recommending $1,000 bail. The problem is he's got other pending cases between July and today, and he was presumably released on recognizance on those cases on condition that he stay out of trouble.
That $1,000 bill in your court, in your system is kangaroo court. Excuse my language.
The judge remains calm as the defendant continues to argue.
Sir, look, I'd like to change judges or whatever the hell. This guy is biased against me, and if you guys keep me in jail for something I did not do, the police assaulted me after I was walking away peacefully.
You want to talk about bail? Mr. Balaban?
Yes, Your Honor. I just suggest we set for a pretrial at this point.
All right, I'm going to set the pretrial on October 6th at 10 a.m. Mr. Belvoir, your behavior convinces me that you need to stay in jail.
Sir, I would like to make you not my judge and my behavior in court. Guess what? Sir, I got my ass whooped by your little bitch ass officer.
The bail is $2,000 cash. $2,000.
No, you're not getting me any bail.
After setting the bond at $2,000, Judge Putka sets a date for a pretrial hearing.
October 6th. That's all.
Listen to me. I have the right to change my judge. You guys hold me in jail. You decide to make a suit, sir. Yeah, this is the officer right here last night that hurt me. You know what? You guys are all
Belvoir failed to post bond and eventually pled guilty to all charges, including his earlier assault charge. He was sentenced to a total of 24 days in jail. Next, we're in Ann Arbor, Michigan for a bond violation hearing. 56-year-old Raphael Gowski has been charged with operating a vehicle while intoxicated. A year earlier, Gowski was arrested and then released on his own recognizance pending trial. But when he failed to appear at a pretrial hearing, he was arrested again, released on a $25,000 bond, and ordered to not consume any alcohol. Then, after Gowski tested positive for alcohol on 2 separate occasions, he was ordered back to court. Today, he appears before Judge Cedric Simpson to hear if his bond will be revoked. Representing the state is Patricia Reiser. Gowski's attorney, David Goldstein, attempts to explain the positive test results.
My client indicated to me that he does use, on occasion, mouthwash. And on those 2 occasions, that's why there was a small amount of alcohol in his system. The court notes that I believe, I don't have...
That's what he told you?
Yes.
And that's why you're relating that to me?
That's exactly right, Your Honor.
Okay. I've never heard of mouthwash lingering that long. And I'll be honest with you, I don't believe it.
Okay.
At all. But if that's your story, then that's a story you're going to give me, and then I got to do what I got to do. Is that really what happened?
Yeah, I was up late watching football, yes, with my girlfriend.
I don't doubt that. You're saying that's the reason for the alcohol?
Had a glass of wine with my girlfriend.
On both of these occasions?
She drinks wine.
Yeah. That's what I thought happened. You actually drank.
I apologize to the court.
Judge Simpson checks in with the attorneys.
What were we intending on doing on the case?
Your Honor, I did have an opportunity to discuss the matter with Ms. Reiser. We were going to ask for about a 30-day adjournment. She indicated she was not going to make an offer until my client earned an offer.
Yeah. This probably didn't help. I guess it wouldn't be wise to adjourn this out 30 days. I will find that the defendant violated his bond conditions of no alcohol use. Defendant's bond will be set at $25,000. I'll give a 10% privilege at case defendant is remanded.
The judge set a new bond of $25,000, and after 5 days in jail, Grabowski paid it and was released. He later accepted a deal from the state and pled guilty to the lesser charge of operating while impaired. He was sentenced to 5 days' time served, plus 2 years probation. Next, we head to Cadillac, Michigan for a bond violation hearing. 58-year-old Joseph Bowen has been charged with possession and delivery of a controlled substance, methamphetamine. After his bail hearing, Bowen was released on a personal recognizance bond and ordered to undergo regular drug testing. But when he missed multiple tests, Bowen was ordered back to court, where he tested positive for meth and was remanded into custody. Today, Bowen appears with his attorney, Jeffrey Harrison, before Judge Jason Elmore to hear if his bond will be revoked.
Mr. Harrison, what are we doing?
Your Honor, Mr. Bowen is prepared to accept responsibility.
Well, Mr. Bowen, you understand, and you hereby admit to testing positive for a controlled substance because you would use a controlled substance?
I do, with explanation, no.
Well, let's go ahead. Let's hear what your explanation is. Don't tell me you smoked a cigarette with something in it. That's the most popular one I hear, and I know to buy it.
I found a box in my closet.
Okay.
And I'm cleaning it out, and I found some. And
found some what?
Methamphetamine.
Okay.
And I wasn't using much, but I used, and
okay.
Handling that, I believe it went through my skin. I did not ingest it.
Okay, don't even try that.
I'm not sure.
No, I'm not gonna buy it. Let's just stop it. I don't know who in jail, no, stop. I don't know who in the jail is spreading these concepts. You can go back and tell them it doesn't work. No, stop talking. Ms. Perry, let's go ahead and put on a witness.
Thank you, Your Honor. People call this business.
It went through my skin.
After hearing from a jail employee who confirmed the positive drug test, the judge makes his ruling on the bond violation.
The court hereby finds the defendant in violation of his bond. I don't think any argument is necessary. There's no evidence produced other than the test. Mr. Bowen, you came in here and tried to lie to me. There's no way I'm going to allow you back on bond. You tried to tell me it went through your skin. Don't even talk. It's just not going to help you. No, don't. I'm going to send a message back to that jail through you. Do not come in here and tell me it went through your skin by accidentally touching it.
I was not trying to lie to you. I was trying to tell you how it became to that use.
Okay, so it went through your skin?
No, I handled it, and once I handled it and I seen it, there was just a little bit there. I used it.
Well,
I never said
I appreciate
that it went through my skin, sir. I think that.
All right, well then
Your Honor,
maybe I misunderstood, but you were starting to go down that road, but I'm going to tell you what, the answer is today, the court's revoking your bond and remanding you to the custody of the jail.
There's no way I can get a bond or.
Not right now.
I'm just.
The answer is today, hold on. The answer is today, your bond's revoked. You were continuing to use the substance that you're charged for possession with intent to deliver. Thank you. We are adjourned.
Bowen eventually pled guilty to possession, and the delivery charge was dismissed. He remains in custody as he waits to be sentenced. If convicted, he could be facing up to a year in jail, plus a $2,000 fine. Next, we're in Wyandotte, Michigan for a bond violation hearing. 30-year-old Anthony Carmona has been charged with disorderly conduct. 3 months earlier, Carmona was arrested for being intoxicated in public. When he appeared at his arraignment before Judge Elizabeth DeSanto, his mood was decidedly friendly.
Yeah, can I say something?
Sure, sir.
And this is the only time I can say this, you're very pretty. And I'm just gonna leave it at that, and I'm done. I'm not saying it again.
Okay, thank you, sir.
Why did I say that? Okay, all right.
That's not going to affect your bond determination, I can tell you
Oh,
that.
I just needed you to know that truth. That's all.
Okay.
They can't take me to jail for that one, because that's the truth, baby. I'm held under oath.
Carmona was released on $2,500 bond and ordered to wear an alcohol tether and regularly report for drug and alcohol testing. But when he missed a few tests and failed another one, both violations of his bond, he was ordered to reappear before Judge DeSanto to enter a plea. Carmona appears remotely, and he's represented by attorney Christopher Schemke. And today, there's no flirting or playful chit-chat.
As to the allegation that you tested positive for marijuana, as well as failed to appear for testing in violation of this court's bond conditions, how do you plead?
Guilty.
Will accept your plea. Counsel, why should I not revoke your client's bond and have him remanded to jail until his next court date?
He had used marijuana, but is not currently using marijuana. As to the missed court dates, unfortunately, Mr. Carmona did suffer an extreme loss. He was seeing someone, he was in a romantic relationship, and that person had an overdose and passed away. It was a challenging period of time. It still is.
And sir, why didn't you appear for the testing?
I was actually trying to go to that hospital the next day. My main focus was seeing her. That day, I can say I wasn't thinking clearly.
Here's what the court's going to do. The court's going to indicate 10 days jail for your bond violation.
In Wayne County?
Yes, sir.
Ma'am,
Wayne County.
please, no, please. I can't. I literally, please, no, please. I will do anything, anything. No.
What you're going to do is you're going to be reporting to Wayne County Jail tonight at 6 o'clock.
No, please. Judge DeSantis, please. I'll do anything. They're gonna kill me in there. If I'm being honest with you, it gives me suicidal thoughts.
Given his state of mind, Judge DeSanto decides to keep Carmona on the call while police try and determine his location.
Sir, you're indicating that you need some mental health treatment. So where is it that you're at?
I'm not gonna tell you where I am.
Why not?
Because you guys are gonna come get me and throw me in jail. I just told you I can't go.
I'm making sure that you are safe and that you're not harming yourself.
For the next 3 hours, Judge DeSanto keeps Carmona occupied, while her other cases are forced to wait.
You act like I'm some crazy criminal. I got drunk one night. Have you never gotten drunk? You know what's really funny is that Wyandotte held the Guinness Book of World Records for a while for the most bars and churches per capita. There will be a suicide on your hands if you cannot help me here.
Sir, I'm trying to help you.
Eventually, police figure out Carmona's at a nearby hotel and appear outside his door.
No way. Really? Oh my God.
What's that?
I knew this was gonna happen, man. You guys are really locking me up.
I said you're okay.
I'm fine.
You said some questionable stuff I was telling you.
Guys, please. No, I'm good.
I'm not gonna do that. Do you still need a sign here, ma'am?
No, that's okay.
Police take Carmona into custody and bring him to a mental health facility for evaluation. 7 days later, he appeared again before Judge DeSanto to hear his sentence.
How are you doing?
Well, better.
Good. So you spent a few days in treatment, correct?
Yes.
All right. And then you were given some medications?
Yes.
And are you taking those medications?
Appropriately.
Okay. I'm encouraged to see that you seem to be taking your mental health seriously at this point.
Yes.
The judge sentenced Carmona to 12 months probation, which included mental health counseling and continued drug and alcohol testing. As for the 10 days in jail for violating his bond, he received credit for the 7 days he spent in treatment.
Thank you.
The remaining 3 days have been suspended by the court, pending Carmona's successful completion of probation. Next, we're in Adrian, Michigan for a pretrial hearing. 39-year-old Stephanie Rice has been charged with 3 counts of aggravated stalking in 2 separate incidents. Over the course of a year, Rice was accused of stalking her ex-husband and his girlfriend. Rice, who has 2 children with another man, was released on $10,000 bond with the conditions she appear at follow-up hearings, be regularly drug tested, and that she check in with court services on a daily basis. After Rice failed to appear at multiple hearings, she was held in contempt and a warrant was issued for her arrest. She was later released on a new $75,000 bond. Today, after further violating her bond by testing positive for methamphetamine, Rice appears before Judge Anna Marie Anzalone.
Ms. Rice is charged with aggravated stalking, which carries a maximum penalty of up to 5 years in prison and/or a $10,000 fine.
The judge hears first from State Prosecutor Phoebe Meir.
In preparation for the trial, I did meet with the victims in this case, and they are quite frankly just fed up with this at this point. So I will dismiss these felony charges as well as the PPO violations and ask the court to sentence Ms. Rice to the maximum on the contempt of court.
Judge Anzalone then checks in with defense attorney Salvatore Malaro.
Mr. Malaro, are you going to object to dismissing the underlying file as well as the PPO violations?
Judge, no objection to any of that.
Very good. I will move to the issue of sentencing on the contempt of court.
I'd ask the court to use its wisdom and fashion the most lenient sentence as any jail time as it possibly can.
Ms. Rice, is there anything you'd like to say on your own behalf?
Yeah.
Okay, I need you to go stand at the podium for me.
An emotional Rice addresses the court.
I know that my kids will be in foster care if I go to jail. I don't have anybody to watch them. Their dad has not seen them in over 2 months. And I'm not using.
The judge looks for confirmation from a member of court services.
Mr. Coast, you administered a test today to her, is that correct?
Yes, ma'am.
And did she test positive for anything?
Tested positive for the THC, amphetamines, but also methamphetamines.
All right, so Ms. Rice, we've got multiple tests showing your levels are dangerously high. So I have great concerns about your mental health, your physical health, and your just defiance from day one of the court's orders, and also a downhill spiral that I'm seeing in your behavior. You know, I think you got off very lucky today because the charges are being dismissed, but I am going to sentence you to court or to jail for 93 days.
Please don't do my kids will be in foster care. Please don't. Please,
Get
Judge.
credit for any time you've already served.
Can you please
Drop
just
that.
give me a try? Please,
No.
Judge. Please, I'm begging you. I'm begging you. My kids are going to be in foster care. I'm begging you. I'm begging you.
Judge Anzalone leaves the hearing as deputies attempt to take Rice into custody.
Don't touch me. Don't touch me.
Rice was taken to the county jail and served her 93 days. Her 2 children were placed in the foster care system. Rice's 2 aggravated stalking cases were later dismissed, and she's currently working to regain custody of her children. Next, we're in Atlanta, Georgia for a bond modification hearing. 38-year-old Tama Ali has been charged with cruelty to children and simple battery after, according to police, she got into a physical altercation with her 16-year-old daughter. Ali was charged and released on $12,500 bond. As part of her bond conditions, she was ordered to have no contact with her daughter and stay away from the home. Today, Ali appears before Judge Alex Manning, hoping to have her bond modified for medical reasons. She's represented by a public defender, Hannah Rondon.
Go ahead, Ms. Rondon.
Recently, Miss Ali has been diagnosed with cervical cancer and has started treatment. Being unable to live in her own home has caused her major issues with recovering. She's had to live out of her car. So we are asking for, one, the stay away order to be amended, and also for the no contact order to be taken away.
Rondon then brings up the Department of Family and Child Services, commonly known as DFACS, which had opened its own investigation regarding the incident.
It's my understanding that that DFACS case has been closed, and that it has been closed because the allegations from the child, she admitted she made them up. I was told DFACS was going to be on here to speak to that.
Is anyone from DFACS here?
Since no one from DFACS is on the call, the judge turns it over to the prosecutor, Celeste Patton.
My position is to object. If Your Honor is inclined, I would like to hear from the minor child. I think she is on here.
All right, can you turn your camera on for me?
The alleged victim appears on the Zoom and is sworn in.
Will you tell the court whether or not you have stated to DFACS that this incident did not actually occur? Did you hear my question?
If you're close to somebody, you need to get away because there's feedback.
When mother and daughter both move to avoid feedback, Patton and Judge Manning come to a realization.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
The judge is not happy.
So right now, what you're telling me is you're violating your own bond conditions before I say you can amend them.
I had no choice. I've been reading.
Stop talking. Stop talking.
Miss
Stop talking.
Ali.
Stop talking. A child.
Miss Ali,
Stop talking. Miss Ali, stop talking. Absolutely nothing you say is going to help you right now. Ms. Patton?
Your Honor, based upon that, I would object. I think it still stands. She hadn't even stayed with the conditions as they are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
I feel my blood pressure going up. Wait a minute. Miss Ali, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions.
To you and lied to you.
Miss Ali.
Absolutely nothing you can say. Ms. Rondon does not want you to
Miss
say
Ali.
a word. It is not going to help you. So, Ms. Rondon, I'll tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ali. And then put it back on for another motions hearing.
Your Honor, I do appreciate that chance.
Thank you, Ms. Rondon. Best of luck to you, Miss Ali. Have a good evening. But you need to leave where you're at.
2 months later, Judge Manning agreed to modify the bond and allow Ali to move back in. Next, we head to Flint, Michigan for a bond violation hearing. 43-year-old Jason Harris has been charged with domestic violence. 6 months earlier, Harris was arrested after an alleged incident involving his girlfriend. He was released on $10,000 bond, ordered to attend anger management classes, and have no contact with the alleged victim. Today, Harris appears from the county jail before Judge David Goggins after allegedly violating his bond. He's represented by public defender Heather Bernash.
It's alleged that you violated your conditions
by having either contact with the victim in this matter.
What happens when they stay in contact with you, though, and you're not trying to have contact with them?
Judge, it sounds as if the victim has reconsidered and changed her mind regarding the relationship.
Y'all find this funny?
I'm sorry?
Harris doesn't seem to appreciate what appears to be laughter from the judge.
Y'all find this funny?
I'm sorry?
Laughing, so do you find this funny or something?
I'm sorry?
I don't find it funny.
Oh, neither do I. I'm glad you don't. Talk to you like that?
I'm sorry?
You talk to
I can't hear what y'all are saying very much.
Listen carefully. Are you going to talk to me like that? Is that what you're doing?
Well, no, I'm just saying it looks like y'all are giggling and all. I mean, I don't find this to be very funny.
Yeah, I don't either. And the other part of it is you were not to have any contact with her. Were you having contact with her?
I wasn't having contact with her. She run into me at Walmart, found out where I lived, and then continued to come to my home and kept coming there. I wasn't looking for contact.
That's a violation of what agreement we had. I took your
What agreement? I didn't contact her. She follows me around everywhere.
You had contact. You didn't walk away.
I walk away, but she follows. What else am I supposed to do?
Walk away.
How can I walk away if she constantly follows?
You violated the terms of our agreement. Find that you violated that, I'll adjudicate the guilty plea.
How can I walk away if she follows, Your Honor?
You gotta figure it out. I'm giving you 82 days. You're all done.
Oh, man. This is some bull, man. After she follows me around?
You know what? Sit back down. Listen up. Hey, deputies, I need to bring back in.
A deputy returns Harris to the hearing.
What am I supposed to be happy about? I mean, I'm getting 82 days for a girl following me around.
For your mouth. 10 days extra for contempt.
Wow. And then she follows me around. But she's the one who's really breaking the order, though. Why am I getting punished for her actions?
Walk out very quietly. I let it in and be more contempt.
Why am I punished for her actions?
I'm not arguing with you. 10 days contempt.
Well, I'm arguing with you. Why am I being punished for her actions?
20 days. Walk out quietly, sir. Right now.
Harris was sentenced to a total of 102 days in jail, 82 for violating his bond, and another 20 for contempt of court. He pled guilty to his original charge and was sentenced to 102 days, time served. The case is now closed. Next, we're in Traverse City, Michigan for a bond violation hearing. 40-year-old Curtis White has been charged with unlawful driving away, 3 counts of obstructing an officer, and being a habitual offender. 2.5 months earlier, police say they spotted White driving a stolen car, and when they questioned him, they say he became confrontational and was arrested. White was released on $25,000 bond, with the condition he be regularly tested for drugs and alcohol. Today, White's in the local jail because he missed 4 days of testing, and a bench warrant was issued for his arrest. He appears before Judge Charles Hamlin to enter a plea on his bond violation. His attorney is Jacob Graff.
Mr. Graff, let me start with you. Have you had a chance to review the allegations contained in the bench warrant with the defendant, and how would you be proceeding this afternoon?
We have, Your Honor. He'd be accepting responsibility to violating his bond.
So, Mr. White, sounds like you want to admit to missing the tests. Is that correct?
Correct.
You did miss those tests, even though you did know that you were required to take them as part of your bond. Is that correct? Okay, the court doesn't feel comfortable at this point taking a plea from Mr. White. I'm not sure where the lack of understanding between either he or I is taking place. So I think what we're going to do is I'll enter a not guilty plea on his behalf, and we'll get it set for a hearing.
The judge moves on to whether White should receive a new bond, beginning with a statement from the defense.
Mr. White was released on a bond. We seem to be doing well. It sounds as though there were some hiccups and maybe, he fell off the wagon and didn't follow through as he should have. I know the court may not be inclined to reinstate the prior bond, but Mr. White would like me to ask to see if the court would give him another opportunity.
Mr. Atwood, any comment for the people?
That's State Prosecutor Kyle Atwood.
Yes, Your Honor. I would ask that he be remanded pending the hearing. The allegations have to do, in large part, with substance abuse, and I'm not so sure that he's not under the influence of something right now. This involved the theft of an automobile, and he fought with law enforcement. So he's a public safety risk. If he's not testing, I'm going to assume he's using. If he's using, he's a danger to everyone else around him. So I think he's where he needs to be. Thank you, Judge.
After hearing from both sides, Judge Hamlin's ready to make his decision.
Well, I think given the issues that the defendant has had on bond in the past, he's already gotten the second chance.
As the judge goes on, White expresses his feelings to the court, not once, but twice. And the judge takes notice.
For the record, Mr. White was just flipping off the camera. He used both his left and right hand to do that. I probably would have been inclined to let it go had it only been a quick reference with one hand, but he did it with both, and he made an aggressive gesture toward the camera while doing it. Mr. White, I'm going to hold you in contempt of court, sir, and I'm going to sentence you to 60 days on that. There won't be any additional fines and costs associated with it. Mr. Graff, we'll see you both back for the hearing that'll occur shortly.
Thank you, Honor.
White was sentenced to 60 days for contempt. He was never charged with car theft, but the case for his unlawful driving away and obstructing an officer is pending.